Good evening, everyone, and thank you for the latest instalment in our CPD series from Greenway Chambers. The series for this year is now drawing to a close. This is the second last seminar in this year's series, and it has been an enormously successful series, and we're grateful to everybody for your participation in it. My name is Derek Hand. I'm a barrister here at Greenway Chambers, and my task this evening is to introduce you to tonight's speaker, Sam Sykes. Sam is a barrister at Greenway Chambers who appears in disputes in commercial law and equity, including in corporations and insolvency, real property, construction and professional negligence. Sam will talk to you tonight about the court's inherent supervisory jurisdiction, including its oversight of the conduct of legal practitioners. Sam's presentation will explore, in particular, the recent Court of Appeal decision in Hartnett and Bell, in which Sam appeared for the respondent. Sam.
Thank you for that, Derek. Welcome to those of you in the room, those watching online, and those who have got it on low as they watch maths tonight. As Derek said, my topic is the court's inherent supervisory jurisdiction, and in particular through the lens of the Court of Appeal's decision last year in Hartnett and Bell. It's not a particularly new area of law. It's been around for a very long time. It's in that regard not particularly novel, but in the circumstances of the case, I think it was a timely reminder of its the breadth of its operation, and also a timely reminder to the profession that when necessary, the court will flex its muscle when solicitors step out of line. And I'll let you all be the judge of whether you think the solicitor in this instance stepped out of line. You can see from the slides there are some statutory sources that provide the court the basis for the jurisdiction. The first is, as I said, not new. It's Section 23 of the Supreme Court Act. And you'll see there that it is a very broad power that entitles the court to do whatever it deems necessary for the administration of justice in New South Wales. And I'll take you through in a moment some of the more orthodox uses of the jurisdiction and ways in which the court will deploy it, especially in circumstances of case management and ensuring that proceedings are conducted in a proper way. The second is particularly relevant to tonight's topic with respect to oversight of solicitors in the conduct of their duties, and that's in the legal profession uniform law. It basically says that just because there are now rules and statutes in place does not mean that the supervisory jurisdiction as it exists for superior courts has gone by the wayside. You'll see there up on the screen some of the usual ways and the traditional uses of the jurisdiction. So there's nothing that should come as too much of a surprise to anyone in these slides. The court will preserve subject matter when it otherwise runs the risk of being dissipated, sold, removed, destroyed, taken, whatever the case may be. There's nothing unusual about that. Staying and referring proceedings to arbitration is very common, particularly in cases where one party seeks to invoke the operation of an alternative dispute resolution clause or something similar. Some other instances, summary judgment, contempt is one of the more commonly used, or one of the times that the jurisdiction is often invoked. And the second last on the screen there, protective jurisdiction, including children and incapable persons. The parents patriarch jurisdiction is one of the critical arms of the Supreme Court and draws upon its inherent power to do things that are right. For the most part, those dot points that have been on the slides, the last two slides, relate to case management, but it's the last dot point that should be of some interest to certainly the people in the room and watching on, is how the jurisdiction remains relevant and can be exercised over legal practitioners. In 1983, Keith Mason wrote a paper that has received considerable judicial support. One of the statements that he made is that it is up on the screen, and you can see from the extracted part there that there are several aspects of the jurisdiction. The first is it addresses misconduct, negligence and default in the conduct of cases in the court. So this really looks at that more traditional deployment of the jurisdiction, which is to say solicitors have an obligation to run proceedings in a certain way. They must be case managed appropriately. And if you, as a solicitor or a barrister, drop the ball in running it, then you are at the whim of the court in relation to disciplinary matters, and also the question of costs. As we know, so long as the costs jurisdiction is exercised judiciously, it's an unfettered jurisdiction, so the courts will avail themselves of all powers necessary. More recently, we have His Honour Justice Hammerschlag's statement of principle that was not overturned and was endorsed by the Court of Appeal in these proceedings. In summary form, Adanaskevich, Hartnell and Berkatu involved an employee of the firm of Adanaskevich Hartnell fraudulently directing payment from a bank into his own personal account. Once that came to light, the short version is that Adanaskevich Hartnell was retained to investigate any fraudulent conduct and determine what had happened. The issue that arose in that case was whether or not it was then entitled to charge its client for fees incurred. There was an issue about an oral undertaking given, and His Honour had those passages to say. Well, His Honour had a number of things to say. The passages that I've put in bold really go to the heart of the jurisdiction, which, as you can see, it's designed to impose on solicitors higher standard than the law generally applies, and is aimed towards ensuring honourable conduct of members of the profession. And if you continue reading up to the second part in bold, it says it is unaffected it is distinct from any legal rights or remedies, and is unaffected by anything which affects the strict legal rights and avoids technical principles. In other words, if there is a whiff to it, the court can intervene. It, as I think is also clear from this, it draws upon what amongst solicitors and counsel and the judiciary is a very important topic, but things you would never dare utter to your mates at the pub, which is that we are officers of the court and have a duty as part of that. It ensures, as His Honour said in these passages, that the standards of propriety are at the forefront and are to be maintained at all times. It's against that backdrop that I take you through the decision in Hartnett and Bell. So Mr. Bell was the executor of his mother's will and was the sole beneficiary. His mother died in 2013. Mabel's death triggered repayment of a $30,000 mortgage that was secured by the property, a piece of real property in Ballina. As a result of a former property settlement, it wasn't a mortgage to a bank, it was to Gwendolyn Deakin-Bell. Mr. Bell attended solicitor's office and asked for a grant of probate. For various reasons that won't get into, no grant of probate was obtained. Mabel retained Mr. Hartnett, a solicitor on the Gold Coast, and instructed Mr. Hartnett to act in possession proceedings against Mr. Bell. Mr. Hartnett issued a costs disclosure to Gwendolyn. It had an initial estimate of a maximum of about $6,700 for the work to recover the proceedings. It was said to be a deferred payment agreement, meaning that he would only be paid at the end of the proceedings or when instructions are withdrawn. There were also clauses in the costs agreement for payment of care and consideration, which I think is an acceptable part of a Queensland cost disclosure. But I think it's a scaled rate. There's a practice note about it that says, depending on the difficulty, the level of work required, it may be appropriate to apply a percentage increase on top of the invoice. And lastly, there was also an uplift fee of 25%. So that was the initial engagements. There was some back and forth between Gwendolyn and Mabel through their solicitors in 2014. It didn't resolve the matter. Mr. Hartnett, Gwendolyn commenced proceedings by way of statement of claim for possession, seeking repayment of the $30,000 mortgage. By that stage, the lawyer's costs listed on the statement of claim were said to be in excess of $30,000. Again, some back and forth between filing of the statement of claim and then December of 2014, at which point Gwendolyn filed for default judgment. That application was rejected because by that stage Mr. Bell did not have a grant of probate and accordingly was the wrong defendant. I think a further $70,000 were billed in the interim between filing the statement of claim and the default judgment application. Over the ensuing 18 months, there was a process undertaken to try and recover funds. Once again, unsuccessful. Defendant was changed to the New South Wales trustee and guardian, and at that stage, the costs between filing the failed default judgment application and bringing in a new and naming the correct defendant, a further $95,000 worth of fees were billed to change the name of the defendant and send some correspondence. Ultimately, once the correct defendant was named in April 2016, a consent position was reached, the proceedings remained undefended, and the normal sorts of orders were made for judgment of about $37,000, including interest, costs payable in accordance with the terms of the mortgage, and that was referred to in the costs order and is significant for what followed, and the proceeds of any, or the surplus of any sale being paid back into court. Now, in October 2016, Mr. Hartnett, on Gwendolyn's behalf, wrote to the New South Wales trustee and guardian and indicated that his fees would be. So those are the orders that were made, as you can see there in Order 5.2. That's the costs order that was made and was ultimately found to have been assessed by a cost assessor. By that stage, we're up to about October 2016. The property had exchanged for a sale price of $376,000, and Mr. Hartnett wrote to the New South Wales Trustee and Guardian and indicated that their fees would be somewhere between $302,000 and $330,000, which incorporated a further $58,000 approximately between judgment and the sale. So as you can see, the figures that we're talking about are quite significant, considering the mortgage was $30,000. That triggered Mr. Bell to formally retain a new solicitor who began agitating for provision of some invoices, cost disclosures, all the ordinary things that one would expect to be requested in assessing whether or not the costs charged were reasonable. After initially being told in about November 2016, yes, we'll keep you abreast of what's happening, was then met with radio silence. Mr. Bell obtained a grant of probate in November 2016, and that formed the basis for requesting further information. It wasn't until a complaint was made to the Queensland Legal Services Commissioner saying that they'd received nothing in reply from Mr. Hartnett that a response was garnered. You can see on the screen that I failed to mention in November 2016, more than 100 pages of invoices were issued on the 14th of November 2016, and then shortly after the property settled, you can see there the figures that were authorised to be paid to the various parties, including the $288,601.03 to be paid to Mr. Hartnett on account of his legal fees. Fast forward to 2018, after a year of squabbling over whether or not Mr. Bell had authority to request copies of the invoices and whether the grant of probate was properly obtained, a cost assessment was undertaken. It was labelled party-party, but as was found at first instance and by the Court of Appeal, it was properly an indemnity costs order in accordance with the terms of the mortgage, because the cost assessor was provided with a copy of the costs order made by Justice Davies and said, I'm assessing it on that basis. So the ultimate figure, despite no input from anybody, was $40,000, less the application fee of about $2,500 or something in that range. After 2 more years of trying to recover those funds, proceedings were ultimately commenced in September 2020 by way of summons and affidavit in support that later became a statement of claim, where it became what became apparent to Justice Slattery, who heard a notice of motion to have this summons set aside, was that the figures involved were quite alarming and needed some explanation. The 2014 possession proceedings were reopened and ran alongside the newly formed proceedings in the equity division. Excuse me. Over the course of 2021, there were a number of directions hearings where issues were raised about whether Queensland or New South Wales was the correct jurisdiction, the scope of the mortgage costs provision that entitled Mr. Hartnett to his fees, and other matters, including the application of the inherent supervisory jurisdiction. Justice Slattery handed down quite a sizable procedural judgment on the 12th of October 21, indicating that you would not refer the matter out to costs assessment due to the amount of money that had been spent already and the fact that there were already proceedings on foot, and the court was entitled to maintain control of the proceedings in the circumstances. What followed was an order for amended pleadings. It was pleaded in the equity division as a priorities dispute and a restitution claim. The restitution claim ultimately failed, but that was no impediment to orders being made. The other critical point is at numbered point 6 on the slide, which is that a points of claim document was ordered to indicate how the inherent supervisory jurisdiction was engaged, in that document, Mr. Hartnett admitted that it applied to him, notwithstanding the fact that he was a Queensland-based solicitor. Proceedings ran in August 2022 for 2 days before Justice Peden. The issues that were thrown up, it was made quite, I'll start that again. Her Honour rejected the restitution claim on the basis that there was no vitiating factor properly brought into the proceedings, but that in circumstances where there had already been a costs assessment undertaken that was found to be binding, that bound Mr. Bell and Gwendolyn as against each other, namely to the tune of the $40,000. And that was a critical point. Her Honour then considered in some detail the scope of the supervisory jurisdiction, cited the passage from Justice Hammerschlag and Adanaskevich, Hartnell and Berkatsu and a number of others, that and relied on those to say that where dishonourable conduct is involved, the court's powers are enlivened. And one of those means by which the jurisdiction is enlivened is exorbitant or excessive charging. The relief sought in those proceedings, by way of in the defence, and the case that was run by Mr. Hartnett, was ultimately said this should be flicked off to cost assessment or a traditional mortgagee accounting scenario take place. That's how this would ordinarily be done. There's no need to dip into the court's inherent supervisory jurisdiction. That argument was developed in more detail at the Court of Appeal. But ultimately, Her Honour found that at first instance, there had been the exorbitant overcharging and some of Mr. Hartnett's conduct in the proceedings warranted the court's intervention, and said that Her Honour was satisfied that the cost assessment was binding between mortgagor and mortgagee, and then said in any event the appropriate sum that Mr. Hartnett has to disgorge is everything in excess of that, and listed all of the bases for reaching that figure, using the well cited and ordinary principles of quantification in a fixed sum application. The matter was appealed, and this is where the Court of Appeal, Her Honour at first instance applied the supervisory jurisdiction, and the Court of Appeal, I think, probably took it one step further in determining why it was appropriate, and in particular looked at the grounds 1 and 2 of the appeal, which are up on the screen and in summary form, were the nub of the dispute, which was to say that that the application of the supervisory jurisdiction in this context constituted an invalid extension of the principle because it had never been applied in circumstances where it was another party's client. And the second matter raised was that the discretion to exercise it miscarried for a number of reasons, but the main one was that it was not necessary in the requisite sense. In other words, because there were alternative methods and more traditional methods of recovering the money available, there was no need for the court to exercise what is described as quite an extraordinary power. The two more traditional methods that were referred to were said to be a mortgagee accounting and a tracing remedy or a third-party costs assessment. What was put to the court was that in circumstances where there's no question about where the money went, where there's been a costs assessment undertaken, and where there was had already been costs expended finding that position, there would be a real futility in undertaking either of those two aspects. One of the considerations that Justice Peden had at first instance was the principles of sections 56 to 60, just, quick and cheap, at first instance, and where there'd already been a trial, it would have been contrary to those principles to kick the matter off for a costs assessment process, be it in New South Wales or Queensland. And that was particularly in circumstances where during the prior to the 12 October 2021 judgment by Justice Slattery, the parties acknowledged that it was a means available, namely that the matter could be referred for assessment in Queensland as a non-associated third-party payer, and such a position was rejected. The case that was relied upon to say that the jurisdiction was not necessary was the decision of McGurk and University of New South Wales, the details of which are up on the screen. In that case, at first instance, the self-represented applicant was ordered pursuant to statute that they were no longer entitled to send voluminous, scandalous documents to the university's legal team, to executives, to everyone else, because it was interfering with the proper course of justice. That was overturned on appeal by a 2-1 majority, saying that the court's rules didn't extend that far, and the passage relied on by, or the main passage relied upon by the respondents, the appellant in that instance, was to say that there are already where the rules of the court contain appropriate provisions which confer broad powers on the court to give directions or make orders for the conduct of proceedings. There is no good reason in policy or practice to extend the inherent jurisdiction of the court beyond its established scope. To put it another way, it is not necessary to extend the inherent jurisdiction of the court beyond its established parameters where the existing powers of the court are adequate to ensure that the interests of justice are served. That argument was rejected. If you have need to review the scope of the jurisdiction in more detail, their honours, with respect, provide a very useful summary of circumstances in which the jurisdiction arises at paragraph 123 in the Court of Appeal, listing 19 different instances. Ultimately, the passages that were relied upon was that the court has an inherent or general jurisdiction to regulate costs, charges and disbursements claimed by officers of the court to prevent exorbitant demands. The court may exercise its inherent jurisdiction in relation to a solicitor's costs in the way it might think fit. And statutory provisions dealing with the issue of lawyers' costs are complementary to the inherent jurisdiction and do not oust it. And the authority for that proposition that was said to remain binding on the Court of Appeal was the decision of the High Court in Wolf and Snipe, a 1933 decision that, despite the ink having been faded, the ink being faded and the introduction of multiple regimes for costs having been introduced since then, was still held to be good law. And McGurk was said to be distinguishable on the basis that it was about case management and in circumstances very different from what the court was faced with in these proceedings. The Court of Appeal found in the Hartnett and Bell that the two jurisdictions, i.e. the inherent jurisdiction and the statutory jurisdiction, sit alongside one another rather than displacing each other. And the gateway remains, has there been some sort of dishonourable conduct that calls for the court's intervention, including, as the case was here, exorbitant overcharging, what the court found to be excessive overcharging. So as you can see on the screen, those are the passages distinguishing what happened in from the circumstances of McGurk. So as I mentioned, although the appeal ran vaguely on the basis to say that this was an extension of the jurisdiction and this jurisdiction's already established, it needn't go any further. The court found that it was merely applying it in a different set of circumstances, and once the touchstone has been met, and the court can do what it needs to in the interests of justice, so long as each party, and in the ordinary way, so long as each party, particularly solicitors, have been given a right to respond and have been afforded procedural fairness. The other matters that the court considered was the history of correspondence that was in evidence, including what was described as the evasive and threatening nature of the correspondence coming from one side to the other that would have otherwise caused the court to flex its muscles in the circumstances anyway, with the result being that the court dismissed the appeal and held that the amount said to be repayable was to be repaid. You can see, I read the beginning of that passage a moment ago. It's the latter part that may be of some interest as well, because obviously the Civil Procedure Act contains its own rules, and Section 99 about how solicitors can be liable to pay legal fees in appropriate circumstances, but the court made it clear that those two positions sit alongside one another and aren't to be analysed differently. I've included Section 99 up on the slide because that, I think, gives you can see there that refers to matters beyond misconduct, in particular neglect and incompetence, which go to the question of that seems to be again directed towards a party's conduct in litigation, separate and applying a separate test from what the court will require in the court's supervisory jurisdiction. The last issue that was that the court made reference to was the question of quantification, and the Court of Appeal confirmed what's been said in a number of cases, in gross sum costs order cases, which is that the court isn't required to undertake a line-by-line analysis. Rather, it's an assessment, a broad brush assessment based on the material before it. In this instance, it wasn't necessarily the case that ordinarily a court can determine whether or not there's sufficient information before making such an order and potentially shipping the parties off to assessment. In this case, the material was there, the assessment had been done, and the Court of Appeal said that Her Honour, at first instance, used the material before the court in an appropriate way to determine that the figure reached was appropriate. Some of the other lessons to take away from the case, the first is in relation to mortgage costs, and in particular the fact that the court, irrespective of private contractual rights, the court can still intervene in circumstances when the costs are excessive. The sort of clause that's up on the screen is pretty standard, namely that mortgagees will try to recover all of their costs of enforcement on an indemnity basis or a solicitor-client basis, and those are usually upheld, but it is still open to a party to bring a claim to have those figures assessed if they seem to be unreasonable, and that's usually the way that those sorts of clauses are interpreted from an assessment perspective, is to say only those fees that are unreasonable will be disallowed. The second was an issue that arose when Mr. Hartnett's interests ceased to be aligned with that of his client, and that is one of conflicting duties between the parties. And this was one of the case I've referred to there, Maloof and Constantinou, is one of the cases referred to in the summary at paragraph 123, talking about the often conflicting duties between solicitor and client. On that occasion, this is a useful case to be across, particularly if you enter into these sorts of costs agreements. Solicitor sought consent declarations from Justice Parker that the client's property could be charged in the solicitor's favour to secure repayment of fees. Justice Parker held that in those circumstances, the conflict is so great arising from the fiduciary relationship, because the solicitor wouldn't know about the availability of property to charge but for the fiduciary relationship, and said it's necessary in those cases to be referred off for other legal advice or run the risk that the declaration will not be made. So always being mindful between duties to the client and the fiduciary duty and how that works is important. The last lesson probably isn't too much of a lesson. I just quite like the passage in the judgment, to be honest. There were probably good reasons in this case why no evidence was put on other than documentary evidence by the defendant appellant, and the court was quite a number of inferences were drawn against Mr. Hartnett about the reasonableness of the fees in circumstances where he did not put on evidence and did not go into the witness box, and the Court of Appeal made it quite clear that the court's entitled to be bold and to make such inferences where somebody with that peculiar knowledge fails to take the few short steps to the witness box, as Chief Justice Bell said. Those are the issues, I think, arising from the substantive case. Something else, just when the case couldn't throw up any more, that I think is worth noting was in the costs argument. So it may not surprise you, but we saw fixed costs in the case, had some scepticism about how quickly a costs assessment process could be undertaken, sought fixed costs before Justice Peden at first instance. An order was made. There was nothing too unusual about that decision other than the fact that there was a costs capping order made by Justice Slattery, and there was some argument about the construction of orders in that case. But I think the costs decision in the Court of Appeal is of some interest because there was previously conflicting authority about whether or not a fixed sum costs order constitutes a variation of an order for the purpose of Rule 36.16 of the UCPR, or whether or not it is an additional order. There were two competing lines of authority that were set out. One which was put forward by Justice White in Short and Crawley, and another by Justice Leeming sitting alone and in Obiter in Riverstar and Fraser Clancy Lawyers. Justice White said that it's not a variation of an order for the purpose of the rule, and that section 98.4 provides the time limit for bringing such an application rather than Rule 36.16, and Justice Leeming said the opposite, that when there's been a determination about a costs order, it must be made within 14 days in accordance with Rule 36.163A. The Court of Appeal turned its mind to resolving those issues and found that in the circumstances there's no claim, or there's no determination of a claim for relief as is required under sub-rule 3, nor does a decision about costs dismiss proceedings in the way required by sub-rule 3B, such that 3A has no application, and that on the proper construction of Rule 36.16, it's an application for a further order. The difference perhaps being if it's said to be as agreed or assessed, in which case the court has already made a determination about the way costs are to be assessed. But in reaching that position, the Court of Appeal endorsed what Justice White said in Short and Crawley, and His Honour subsequently applied, which was to say that in circumstances where there's been no determination, all that's being put forward in the orders is an alternate means of assessing the costs. I think it's implied that if there's no order, if the order is just that one party pay the other's costs, it's implied that it's as agreed or assessed. Where that order is not made, the only time limit for bringing an application for fixed sum costs is prior to them being assessed, or prior to an application for them to be assessed. Where I still wouldn't be sitting on my hands for too long to bring an application for fixed sum costs, because obviously the delay between the conclusion of the hearing and bringing an application would be a factor that the court would consider when determining whether it's appropriate to make such an application. But it still remains, I think, on the basis of this, that you get that what you're obtaining is an additional order that the costs be fixed in a certain amount, and the application can be brought any time prior to assessment. That brings tonight's presentation to an end. You can't see, but there's almost too many people to count in the room here. If anyone's got any questions, now's the time. Speak now, forever hold your peace. No. All right, well, thank you very much for coming and attending these presentations.